Hello everyone, I'm Nazarat Fatima and you're watching LiveLaw. You might have watched the previous video which dealt with the arguments made by Mr. Kapil Sibal today on August 2nd in the matter relating the abrogation of Article 370. In order to understand the arguments we are going to discuss in this video, kindly refer to the previous video labeled as Part 1. In this video, we'll focus upon the arguments made by Mr. Kapil Sibal post-lunch. So, in continuation of his arguments regarding the Constituent Assembly, Mr. Sibal stated that the ordinary law-making power shall be limited to those matters in the Union list and the concurrent list, which in consultation with the government of state are declared by President to correspond to matters in the instrument of accession. And as such, the Parliament can only make laws in matters present in the list, and that also in consultation. He said that the first limb of his argument is the restriction on law-making power. Coming to another aspect, the CJI said that Constituent Assembly is not a permanent body, and once it has fulfilled its purpose, it becomes functus officio. Mr. Sibal replied and said that the problem here is that in this case, Clause 3 is being applied without the proviso, which is blanket power. The CJI pointed out that Article 370 specifically says temporary. He said, and I quote, "Can we say that power under Clause 3 goes once Constituent Assembly comes to an end? Convert this to a permanent provision even though it was not intended to be?" Mr. Sibal argued, and I quote, "You cannot incorporate concepts outside of 370 and integrate them into 370 and say this is how we'll read 370. 370 is not temporary. It is temporary till such time as the Constituent Assembly desires this way or that way. When the Constitution came to force, there was nothing such as a Constituent Assembly. How did the Constitution add this here? Because there was an understanding. Otherwise, why would you bring the term Constituent Assembly under 370? Suppose the Constituent Assembly decided not to be with India. Then what?" The CJI said that two types of temporary provisions exist. One is Article 368, which says Parliament has power to make laws for a period of 5 years. So temporary with reference to time. 370 is temporary in a sense that it is temporary till abrogated. Mr. Sibal said that it was called a temporary provision because that had to be decided by the Constituent Assembly. And then the terms to find out how that power is to be exercised is to be interpreted. He said that the residuary power was already with the state. Right after this, Mr. Sibal started reading from the Constituent Assembly debates. He read, and I quote, "It is one of our commitments to the people and government of Kashmir that no such additions should be made except with the consent of the Constituent Assembly." Mr. Sibal said that it was the commitment that was made. He said that there can be nothing clearer than that. In addition, he read, and I quote, "The recommendation of the Constituent Assembly will be a condition precedent." He said, and I quote, "This explained the whole article, and in 2023, we in hindsight cannot interpret a provision except on its terms." Mr. Sibal said that they're not there to legitimize a process which is inconsistent with the express terms of the Constitution, and instead they're only interpreting the Constitution. He said in addition to this that it was envisaged in our Constitution that it will be constituted and the ultimate authority of abrogating 370 would be with the Constituent Assembly. With that he said, and I quote, "And a precondition of that would be a recommendation of the Constituent Assembly for the President to pass an order. Absent that, it cannot be done." That was the understanding of the makers of Constitution. Mr. Sibal made a very important point. He said that Article 370 was not temporary in the sense that ultimately it has to be abrogated. He said that the abrogation was done through a political act and not a constitutional procedure. And such a political act cannot be determined by the Parliament to take a political decision to abrogate the article. He added that there is a unique relationship drafted in 370 and it cannot be cancelled out except by following a procedure ordained by law. Speaking of another aspect, Mr. Sibal said that the Parliament exercised the will of the people of J&K when they abrogated the article and took upon themselves the constitutional responsibility of saying that now they are the legislature and the Constituent Assembly as well, and they'll exercise the will of the people of Jammu and Kashmir. He posed a question in the court as to is it even possible constitutionally, and is it envisaged in 370, or is it not an exercise of political power? He also asked, and I quote, "Can such a power be exercised in the manner in which it was exercised? That is a matter of procedure." Now, with regard to the conversion of the state to a union territory, Mr. Sibal said that Article 3 says they can change the boundaries, but they did not do so. They changed the entire state to a union territory. Justice Suryakant made a statement that it is quite possible to carve out a union territory out of a state, in response to which Mr. Sibal said, and I quote, "You can carve out, but you cannot have all of Madhya Pradesh become a UT one fine day. That is unthinkable." With regard to elections in Jammu and Kashmir, Mr. Sibal said, and I quote, "So you move away from representative democracy, convert it into a union territory under your direct rule, and 5 years have passed. Every day we hear that there will be elections. There has to be a constitutional basis for doing this." He said if 370 had to be abrogated, there was a possibility. If J&K was to be integrated in India completely, that is fine. But it was a political act and could not have been exercised by Parliament, which is a legislative body. That's all for today. If you wish to read the arguments in detail, please go to our website, which is www.livelaw.in, and check out the top stories section. I'm your host Nazarat Fatima, and I'll be back with part 3 of the arguments very soon. To stay updated, stay tuned to LiveLaw. Thank you for watching.